Hello, my name is Bob Lannon. I'm the principal of Lannon Legal PLLC, a law firm based in Washington, D.C., and much of my practice is focused on transactions in the hotel and lodging industry. I am doing a series of presentations on hotel management agreements, and today's is the third in that series. In part two, we talked about the interests of the parties, the interests of the hotel manager and the interests of the hotel owner. Today, I want to talk about the legal relationship in which each of those parties pursues those interests. And there are four relationships that I'm going to discuss today. The first three are three alternate legal relationships within a hotel management contract. If the contract is drafted well, it will clearly state which of these three alternate relationships the parties have. The fourth is a fourth relationship that it can have in addition to one of these three or not have. But it should have one of these three. And the first relationship is that of an agency. It's an agency relationship. What is an agency relationship? Well, an agent acts on behalf of the principal. The principal is the person who owns a property, and in the context of hotel management agreement, of course, it's the owner who is the principal, and the owner owns the hotel. And the agent acts on behalf of the principal to pursue the principal's interests within the scope of the agency relationship. Of course, for a hotel management company, that relationship is operating the hotel on behalf of the principal. On behalf of, well, that's the first key aspect of an agency relationship. It is a fiduciary relationship. What's a fiduciary? Let me pull out my Andy Black's Law Dictionary here. A fiduciary is someone who is required to act for the benefit of another person on all matters within the scope of their relationship. So, if you are a fiduciary within that relationship, you have to make your interests secondary to that of the principal. The classic example is that of a trust. If you're the trustee of a trust, you are managing some property for the benefit of a beneficiary of that trust, and you owe that person the duty of putting that person's interests up front. What are those duties within a fiduciary relationship? Again, getting back to Black's Law Dictionary, there are a few. The two big ones are the duty of loyalty and the duty of care. There's also a duty of good faith and a duty of disclosure. But the one that really counts for purposes of this discussion is the duty of loyalty. The duty of loyalty means putting the principal's interests ahead of your own if you are the fiduciary. And that can come up in a number of contexts within a hotel management contract. It can present issues. So, for example, it may be a duty not to compete. And let's say you're a hotel management company operating a hotel on one block in a city, and you'd like to operate another hotel that's similar, that's only 2 blocks away. The duty of loyalty would hold that unless otherwise agreed by the parties, you can't do that if they're in direct competition with one another, because there'd be a conflict of interest, and you can't have that. Another area in which this comes up in the context of hotel management companies are affiliate and profit transactions. An affiliate transaction, I mentioned during the last session that management companies often make money from above property service fees. Often those above property services are provided by an affiliate of the management company. So you have ABC Hotel Management Company that operates this hotel, and then its sister company will provide, say, the accounting services or the revenue management services. It may be the management company itself, but sometimes it's an affiliate. Can that affiliate make money? Can that affiliate profit? Certainly not without disclosure and consent in the hotel management company. Otherwise, these sister companies, again, have a conflict of interest that would be a breach of the fiduciary duty of loyalty. The other one is profit transactions. Let's say it's not an affiliate. Let's say the management company is providing procurement services as it does. You've got to buy supplies for the hotel. What if the management company manages a number of hotels and prefers to buy its towels from one supplier of towels, and the supplier of towels says, well, look, if you buy all these towels for your owners, and remember, you're paying the owner's money, the money from the hotel operating accounts to pay for those towels. The manager's not going out of pocket for them. What if the towel supplier says, if you exceed certain thresholds, we'll pay you a rebate, a kickback? Can the management company take that deal to procure those supplies for this owner? And the answer is no, unless it's clearly disclosed and consented to by the management company, not if it's an agency relationship. Otherwise, that would be a breach of the fiduciary duty of loyalty. And the third example I'll offer is one that I touched on during the last presentation, and that it comes into play when the management company is affiliated with a brand. The brand has an interest in enhancing its brand image, and that interest may motivate the management company to spend money, that is the owner's money, on enhancing the hotel's services and resources in a way that enhances the brand image, but not necessarily the bottom line of the hotel. And if the manager is acting against, if it's not profitable for the hotel, for the management company to hire that extra employee or purchase that extra for fixtures, furniture, and equipment or supplies, but the management company wants to do so anyway because it enhances the brand image, does that breach the fiduciary duty of loyalty because of a conflict of interest? And that's an issue that comes into play. So you have to consider whether, even if it is an agency relationship, can these fiduciary duties be limited or disclaimed by the contract? And I think the answer is yes, because so many management companies do it within the context of an agency relationship that if it couldn't be contractually governed, there would be a lot of case law to the contrary, and that case law just doesn't exist. So I believe that the answer is yes, but it has to be carefully done. So let's say you're a management company that wants to be able to have an affiliate provide services to the hotel and for the benefit of the hotel, but the affiliate will make money providing those services, make a profit. That had better be disclosed very clearly in the hotel management contract and consented to by the owner. But the question a management company has to ask is, what do I want to be the starting point? What do I want to be the presumption? Because if the presumption is one of agency with fiduciary duties, then you'd better very carefully have all those limits and disclaimers within the language of the management agreement. If it's not an agency relationship, if it's, and we'll talk about it in a couple of minutes here, if it's an independent contractor relationship, there are no fiduciary duties, and therefore you don't start with the presumption that there are things that you can't do, and then the management company is not burdened to overcome that presumption with language in the contract. Another aspect of an agency relationship to consider is that the agent is presumptively subject to the principal's control. And this is a big issue in hotel management contracts because typically you'll see, it's one of the very first sections of the management contract, a very broad delegation of authority where the owner hands the keys to the management company and relinquishes day-to-day control over the operation of the hotel to the management company. Well, if the relationship is defined as one of agency, then again, there's this presumption that the owner can step in and control the manager and direct the manager's activities. Again, this can probably be contractually tempered by the terms of the contract, and those terms certainly would include that delegation of authority and then well-regulated involvement of the owner. But again, it's a question of where you start as a presumption. The management company may want to avoid agency in order that the presumption is one that the owner does not have a right to step in and control. Otherwise, that right of the owner is going to have to be very carefully limited and regulated within the language of the hotel management contract. A third aspect of an agency relationship that needs to be considered is that under the common law of contracts, a principal has an inherent power to terminate an agency relationship at will. So what does that mean? Well, that means that even if the term of a hotel management agreement has not yet expired, and even if the management company hasn't done anything that would give the owner a contractual right to terminate it, if the management company hasn't defaulted or committed a material breach. Nevertheless, if it's an agency relationship in the contract, the principal, the owner, has a right to step in and say, get out of my hotel, and terminate the contract at will. Now, if the principal does that, the management company is not left with nothing. The management company will still have a claim for money damages because what's said is that the principal has the power to terminate, but not the contractual right to terminate, and therefore the principal will have breached the contract. The management company will have a claim for damages, money, in the form of lost fees. If you exercise this power as an owner after year 5 of a 20-year contract, you owe that management company 15 years of lost fees. But, it's significant for the management company nonetheless because the management company has lost the opportunity to manage that hotel for those 15 years. And it's for this reason that many management companies avoid agency relationships, really for all of the reasons on this slide, but this one in particular. Some management companies go to great lengths to avoid it if they have the bargaining power to do so. Some owners insist on agency relationships. It's really a matter of the party's bargaining power, really, whether this type of relationship exists or not. Unlike the other two, the other A and B on the slide here, I've taken the position that in a majority of jurisdictions, the scope of a fiduciary relationship can be in the contract defined and limited by the terms of the contract. I don't think that's so true under point C here. Otherwise, the case law, which I'm going to discuss in my next presentation, would have turned out differently. These management contracts do say that the manager has the right to manage the hotel for a certain number of years, subject to the terms and conditions of the contract. And nevertheless, under the case law, when it's an agency relationship, the courts have recognized this power for the owner to terminate the hotel management contract at will. So that's the first of the 3 alternate relationships. I'm going to move on to the second here. And the second is an agency relationship, but it's an agency coupled with an interest. So what's that interest? Well, the interest is part ownership of the hotel. And if the agent, the hotel management company, owns a piece of the hotel, then the principal doesn't have the presumptive power to terminate the management contract. Now, to be sure, the other components of fiduciary duties do exist. The management company still has fiduciary duties, and the management company is still presumptively subject to the principal's control. But this one goes away if the management company owns a piece of the hotel. And for that reason, some management companies have taken what's called sliver equity in a hotel, where the management company owns a small percentage of the hotel just for this reason, to keep the principal from having the right to kick them out, or having the power to kick them out. Is the management interest, the contractual rights under the hotel management agreement alone, enough to create an interest? And the answer is no. That's I have a case citation in there in which a court said it has to be an interest in the real estate itself. There's the sliver equity I mentioned. What if it's a sister company of the management company that holds the equity, but not the management company itself? That too is not enough. it has to be the management company itself. And it's for those reasons that some management companies insist on the third type of relationship between the parties, and that's that of an independent contractor. The independent contractor doesn't own any interest in the hotel. In an independent contractor relationship, the principal has no common law power to terminate the contract. The principal has less discretion to control. There's a presumption that the principal can step in and direct the activities of the independent contractor. And an independent contractor does not owe fiduciary duties to an agency, to a principal. And it's for this reason that some hotel management companies, if they've got a lot of bargaining power, insist upon an independent contractor relationship because they want to avoid all the baggage that comes with fiduciary duties under the previous two relationships. And we'll discuss this as well during the next presentation in the context of some state law. I want to shift gears a bit and talk about a fourth relationship, and that's the personal services contract. Whether a hotel management company has a personal services contract is significant. What is a personal services contract? Let me pull out a handy Black's Law Dictionary again. Black's defines it as a contract that requires a party to act personally and does not allow substitution of the person providing the service. People who provide unique personal services often make personal services contracts, sometimes called performance contracts. How do you know if a contract is a personal services contract? Well, courts look to a number of factors. One is the exercise of special skills, judgment, and broad discretion. Another is trust between the parties. Another is subjectivity in evaluating the performance. And another is whether it's a longer-term relationship. Personal services contracts usually, not always, are longer-term relationships. So in the illustrations here, I have a couple of examples. If you hire somebody to paint your portrait, that is a personal services contract. Look at these factors. It certainly requires special skills. There's a relationship of trust there. You're not just going to hire anybody. There's certainly a subjectivity in evaluating the performance. Not so much the longer-term relationship. That one's short, but it's not. You don't have to have all four. The courts will consider whether enough of these factors are present to make it a personal services contract. I think an even better example is the second one in this slide, and that's a babysitter or a nanny. If you hire a nanny to watch your children, that certainly is a personal services contract, and all four of these elements are present. So why is this significant in the context of hotel management agreements? And that's because some hotel management contracts have been deemed to be personal services contracts. So what's the significance of being a personal services contract? Why do we care? This has to do with a particular remedy that's available for a breach of a contract, and it's called an equitable remedy. When you sue somebody in court, you're generally suing for either or both of two categories of remedies. The first is money. That's for, we call that a legal remedy or damages. And the second is called equitable relief, which is an order by the court for the defendant to do something or not to do something. It's this equitable relief that comes into play within the context of personal services contracts. And that is, it's a remedy called specific performance. Sometimes when a party breaches a contract, the non-breaching party cannot be made whole by just being paid money, but can only be made whole, and justice can only be adequately done if the court orders the breaching party to perform its duties under the contract, to specifically perform. And the best example I can come up with is a land sale contract. If you enter into a contract to buy somebody's house, and between your signing that contract and the closing, the seller reneges, and you really want this house, not just enough money to buy an equally nice house, you really wanted this house because of its location. The law has held that money will not make you whole, and that specific performance is available. If you sue that seller, the court will enter an order requiring the seller to specifically perform and sell you the house. So how does this relate to personal services contracts? Courts will not order specific performance of a personal services contract. And this is for a couple of reasons. First of all, if you're the person providing the services, the court will not order you to do work that you don't want to do. And this in the United States is grounded in the 13th Amendment, which prohibits involuntary servitude. The courts are just reluctant to order somebody to do something that the person doesn't want to do, even if the person is going to be paid for it. But more to the point, for hotel management contracts, even if the person providing the service is willing to provide the service, the court will not. If the person paying for the service doesn't want the servants to continue providing it, the court will not order specific performance in that context either. So let's think about the nanny. Now, let's say you hire the nanny and you sign a contract saying, I'm going to employ you in my home to watch my children for 3 months. And after the first month, the family just doesn't get along with the nanny. And you say to the nanny, we're letting you go. Can the nanny sue for specific performance? No, I really want to keep watching these kids, and get an order from the court compelling you to let the nanny back into your home to watch the kids for those remaining 2 months? Absolutely not, because of the nature of the contract, because it's so personal. The common law recognizes that while the nanny may have a claim for damages and you may have to pay 3 months worth of fees, they're not going to compel you to hire this person if you don't want the person to keep providing the personal service. So how does all of this relate to hotels? Well, as I mentioned, some courts have deemed hotel management contracts to be personal services contracts. And in case law, you'll see it's always a scenario in which the owner wants the management company to go away, but the management company wants to stay and is willing to continue providing the service. In some cases, under some states' laws, courts have held, no, a hotel management contract is a personal services contract, and therefore we will not order specific performance and require the owner to let the management company back in to continue managing the contract. We'll get into this in the next presentation, but it makes it important to choose the right state's law to govern your contract, depending on which side of this you're on. If you're an owner, one state that has favorable law on this issue is New York, because under New York law, a couple of courts have held that a hotel management contract is a personal services contract in which specific performance is not available as a remedy to the management company if the management company wants to stay, which would weigh in favor of the owner having the power and the right to terminate if it wants the management company out, even if the owner has to pay some contract damages. But that's it for this presentation. We'll discuss that case law at greater length in the next presentation. Thank you very much for your time today.